Mr. President.
Senator from Rhode Island.
Thank you, Mr. President. Mr. President, I would ask that the quorum of the quorum be dispensed with.
Without objection.
Thank you, Mr. President. Mr. President, I rise today to express my strong opposition to the nomination of Judge Brett Kavanaugh to replace Justice Anthony Kennedy as an Associate Justice on the United States Supreme Court. I oppose Judge Kavanaugh's nomination to his current seat on the D.C. Circuit Court because I had serious concerns about his partisan history, expansive view of presidential power, and his lack of candor about his work in the Bush White House during his testimony before the Senate Judiciary Committee. Judge Kavanaugh's work on the D.C. Circuit demonstrated, as I believe, I was right to be concerned about his view that the president is above the law. I intend to discuss his jurisprudence in a moment, but first it is necessary to list just how many ways in which this process has revealed that Judge Kavanaugh lacks the temperament to serve as a justice of the Supreme Court. He began this process by continuing to stonewall and perhaps even mislead senators about his career as a political operative and partisan lawyer in the Bush administration. He dissembled when asked basic questions about his approach to the law, a tactic we have come to expect from nominees who have been selected and vetted by far-right interest groups. But when Dr. Christine Blasey Ford, Deborah Ramirez, and others came forward with serious and credible allegations of sexual assault against him, this body saw the real Judge Kavanaugh. He emerged at his second hearing combative, blatantly partisan, disrespectful, evasive, and in no way reassuring that he has told the truth to this body and the American people. I'll discuss these in turn, but the bottom line is this. Judge Kavanaugh is unqualified for a seat on the Supreme Court because he lacks the basic qualities and judgment for a position that could affect Americans' everyday lives for generations to come. The American people are watching this debate with serious, real-world concerns about what a Justice Kavanaugh would mean for them. They're worried that they could wake up someday soon to news that a conservative 5-4 majority on the court has stripped them of their health insurance, abolished their right to privacy and control over their reproductive health, or revoked their right to marry whomever they choose. They see inequality of historic proportions, with the top 1% now earning more than the bottom 50% combined, according to the World Inequality Report. And a Supreme Court that continues to overturn laws that were enacted to prevent corporations and wealthy individuals from using their money to rig the political system. It is abundantly clear, given Judge Kavanaugh's selection by special interest groups and the mad rush to confirm him at all costs, that powerful interests are counting on him to further these trends, which point to a future where political power is directly tied to wealth and status. Worse yet, given that we still don't know the whole truth about the allegations against Judge Kavanaugh, continuing this rush to place him on the court sends a terrible message to survivors of sexual assault that accountability for these crimes depends on the extent to which the accused person serves the interests of the powerful. The American people deserve better when it comes to this body's obligation to advise and consent on the next Supreme Court justice, and the majority has failed in that obligation time and again in the course of this confirmation process. When my Democratic colleagues and I expressed concern about whether a president under such serious criminal investigation should, prior to seeing the investigative process thorough and complete to the end, appoint a Supreme Court justice who likely could be called upon to rule on critical matters in a case against the president's campaign, the majority ignored us. When we demanded that Judge Kavanaugh's hearing follow the standard practice for Supreme Court nominees, providing senators and the public alike with access to the nominee's full record of public service through appropriate document disclosures from the National Archives, the majority fast-tracked Judge Kavanaugh's hearing before the National Archives could process the records from his work in the Bush White House. And in place of the appropriate process, the majority enlisted a private Republican lawyer to curate a small subset of records for senators to review, and even that subset was subject to an assertion of committee confidentiality, meaning senators were barred from sharing anything they may have learned about Judge Kavanaugh with the public. Thousands more records were withheld under a dubious assertion of executive privilege. And even given the small number of Republican-selected records made available to this body, my Democratic colleagues on the Judiciary Committee uncovered troubling inconsistencies that call into question whether Judge Kavanaugh has been truthful in his Senate testimony. No other nominee for the Supreme Court would get away with this. Why is the majority giving this free pass to Judge Kavanaugh? Why does he deserve to shield his record when no other member of the Supreme Court receives such treatment? Why must his documents, records of taxpayer-funded public service, be controlled by a private Republican attorney instead of the National Archives, like every other man and woman who currently sits on the Supreme Court? Just what is it about Judge Kavanaugh that has rendered stalwart defenders of the Senate's power to review nominees, including those on the Judiciary Committee, to have such a profound about-face? No one is entitled to a lifetime appointment to the Supreme Court, yet the majority has treated this job like the personal property of Judge Kavanaugh ever since the president announced his nomination. My Republican colleagues have said a great deal about the importance of preserving a fair process for the consideration of Supreme Court nominees. Madam President, some of these arguments are simply outrageous. In the recent past, Democrats in the majority worked on a bipartisan basis to obtain nearly all relevant documents from then Solicitor General Kagan's work in the White House before holding a vote on her nomination to the Supreme Court. Today, we are set to vote on Judge Kavanaugh with roughly 90% of his record still kept secret. Yes, in the recent past, Democrats made the difficult choice to end Republicans' historically unprecedented obstruction of hundreds of President Obama's judicial nominees by eliminating the 60-vote threshold for judicial nominees except to the Supreme Court of the United States, recognizing that the Supreme Court is one of the most important institutions in this country, that it operates as the effective check on both the legislature and the executive, that it is the ultimate interpreter of the Constitution of the United States, and that in order to have members on that court who are consistent with the Constitution and thoroughly accountable to the American people, not special interests, a simple majority to get to the court is inadequate. This process demonstrates that. Last year, after breaking historical precedent and basic decency by denying Chief Justice Merrick Garland so much as a meeting or hearing on a Supreme Court nomination, again, for over a year, the Republican majority refused to consider a nomination of Judge Garland to the Supreme Court. And now they insist we have to move expeditiously to fill this gap. It's so critical. We can't wait 2 weeks, 3 weeks, 4 weeks for a thorough FBI investigation. We have to do it now. But we didn't have to do it when President Obama submitted, pursuant to the Constitution, the nomination of Judge Garland. Once Judge Gorsuch was presented to us, the Republicans abandoned the 60-vote threshold, and in every turn, the Republicans have, in my view, escalated these so-called judicial wars. And this rush to confirm Judge Kavanaugh, despite the allegations against him, brings us closer than ever to a crisis of confidence in the court. And the need for more time, more answers with regard to Judge Kavanaugh's record has become overwhelming since Dr. Ford, Deborah Ramirez, and others came forward. These women have put aside their privacy, professional lives, and the safety and security of their families in order to bring to light their allegations against Judge Kavanaugh. Regardless of how one feels about the truth of their claims, they have been met with treatment that should be beneath us as a nation. They have been mocked and attacked in disgraceful and sexist terms by public figures who should know better, including the president himself. They have been called liars, had their motives questioned, and had their private lives picked apart on a national stage. The Judiciary Committee has now had the opportunity to hear from Dr. Ford, and the FBI has conducted a limited background check on some of the allegations against Judge Kavanaugh. But this process still doesn't pass the simple common sense test. If there is no truth to these allegations, as the nominee and our Republican colleagues claim, why was it so difficult to agree to an FBI investigation in the first place? For that matter, What serious investigation is forced to finish in less than a week with limits on which leads it can follow? What person, upon hearing that a child or relative of his or her own had been harmed, would be satisfied with such a short and apparently outcome-driven process? What is the majority hiding? I'll not parse the details of every allegation against Judge Kavanaugh here today, but I will say this to my Republican colleagues. Look around you. Our nation is undergoing an historic and long overdue reckoning with abuse of power, sexual harassment, and sexual assault. It is regrettable that the Supreme Court confirmation process has once again become a forum for the larger debate about these matters. But there's no convenient way to reckon with long-standing and painful injustice. This is the issue before us, and we must face it. History will not look kindly if it looks at all on those who take the easy way out, using distraction, false equivalence, and personal attacks to preserve a partisan win at all cost. Given the growing number of doubts that this process raised about Judge Kavanaugh's honesty and trustworthiness, he cannot begin to meet the test that I've applied to every Supreme Court nominee, regardless of party, during my service in the Senate. I voted against nominees in the past because I did not believe that their jurisprudential records demonstrated that they would use their discretion to give meaning to the promise of the Constitution. But never before have I had to stand here and oppose a nominee to the Supreme Court for those same very reasons, and because I do not believe that he is trustworthy. I regret that I must do so now. When it comes to Supreme Court justice, character is a non-negotiable requirement. Supreme Court justices are expected to have a record of high personal and professional achievement. They are not supposed to be partisans or politicians. They are given an awesome power for life. They can certainly have flaws, but their relationship to the truth and their willingness to avoid the appearance of emotion are not up for debate. To serve in judgment of 325 million of their fellow citizens, they must be above the fray, particularly in these difficult and divided times. If Supreme Court decisions were simply a mechanical application of foregone legal conclusions, then it wouldn't matter who sat on the court. Rather, justice power rests in the discretion to choose among competing and well-reasoned arguments to decide how the promise of the Constitution will apply for generations to come. In order to support a Supreme Court nominee, I must believe she or he will use that discretion to give meaning to the American tradition of equal justice under law. This means strictly scrutinizing laws that obstruct and distort the effective operation of government and channels of political participation. It means rejecting arbitrary abuse of power and demanding the most compelling justification for laws that single out the powerless and discrete and insular minority groups for disfavored treatment under the law. When the court has acted in accordance with these principles, it has resolved issues of national concern that threaten to tear the fabric of our nation apart, and done so in a manner that preserves the perception of impartiality that is vital to our judicial institutions. The court struck the final blow against legal segregation. It safeguarded constitutional voting rights, guaranteed Americans the power to choose how to start their families, separated church and state for the mutual benefit of both institutions, and even ordered sitting presidents to comply with the law. The snarling, conspiratorial partisanship that Judge Kavanaugh displayed at his second hearing was a far cry from the historical principles that have preserved the court as an institution. Without evidence, he blamed the left and left-wing opposition groups for revelations about his past behavior, calling it a calculated, orchestrated political hit. He characterized Dr. Ford and others as liars and claimed that their desire to come forward was simply pent-up anger about President Trump in the 2016 election. How many of the advocacy organizations that regularly try cases before the court fit his definition of left-wing opposition groups? How is anyone supposed to believe that Justice Kavanaugh would approach a politically charged case with an open mind after this display? I fear that some are willing to overlook the clear defects in this nominee and this confirmation process because they wanted Justice Kavanaugh to deliver long-desired legal victories for partisan causes. President Trump has clearly expressed his expectations for his nominees to the court. It even outsourced the vetting process to far-right special interest groups. The goal of this process is no mystery. a decisive majority of the Supreme Court that will eviscerate the underpinnings of Roe v. Wade and undo the constitutional right to privacy, as well as expand the Second Amendment to block even common-sense gun safety laws. Critically, the President also wants to bring even more functions of government solely under the control of the White House so that he can quickly and easily dismantle protections for workers, the vulnerable, and the environment. This wish list is nothing new. It has long been the agenda of groups like the NRA and the Federalist Society to take control of the Supreme Court and accomplish from the bench what they cannot win from the ballot box. And President Trump and this majority, however, they have found their opportunity to radically change American law for the few and the powerful. I have no illusion about Judge Kavanaugh's familiarity with and enthusiasm for the partisan victories he is expected to deliver for President Trump and special interest groups as a justice. It is also difficult for me to imagine that that would be such a rush to put Judge Kavanaugh on the court if he were not a lifelong D.C. political operative and reliable partisan and an architect of the conservative legal movement, which is designed to pack the federal judiciary with outcome-driven ideologues like him. He has already amassed a body of work that shows how he can and will deliver for the movement that has groomed him for this moment. Judge Kavanaugh has demonstrated a dangerously expansive view of presidential power. The president is not a king, and this is because the Constitution establishes separation of powers and a system of checks and balances to ensure that no arm of government can overpower the others. The framers recognized that particular danger of a Supreme Court without judicial independence. In Federalist 78, Alexander Hamilton quoted Montesquieu saying, quote, "There is no liberty if the power of judging be not separated from the legislative and executive powers." He added, "Liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments." Based on his writing, I fear that Justice Kavanaugh is predisposed to provide the deciding vote on the president's agenda before cases against him even reach the Supreme Court. For example, the Supreme Court has never had to decide whether a sitting president can be prosecuted for federal crimes. It is perhaps more important now than ever in our history to ensure that a nominee to the court can approach questions of presidential accountability with independence and an open mind. Judge Kavanaugh cannot seriously claim to have either on this issue. As a veteran of the Starr investigation in the Clinton White House, Judge Kavanaugh understandably has strong feelings on the issues of civil and criminal prosecutions of sitting presidents. In 1998, Kavanaugh authored a law review article discussing the now-defunct independent counsel statute in detail and recommending changes to the statutory scheme. He argued there that Congress should pass a law prohibiting the indictment of a sitting president until after the president's term in office. But he made it clear at several points that he believes that such a law would codify what to him is already plain in the Constitution, that a president is above our criminal laws while he holds office. His views about presidential accountability did not evolve over time as seen in the various ways he continued to share his views over the years. In 1999, he told a reporter that he doubted whether the Supreme Court got it right in the United States v. Nixon, the landmark case that held that president could not always use executive privilege to escape a subpoena to turn over records in a criminal case. And for those who lived through Watergate, it was the Supreme Court's decision, in that decision, that more than anything else preserved, I think, the stability of the Union and the triumph of the Constitution over partisan politics. It led to President Nixon's resignation. It also showed convincingly that the court could take a decision seriously with respect to the Constitution without considering the political effects. And Justice Kavanaugh believes they were wrong, that President Nixon should have been allowed to defy the court, defy the country, and maintain secret the tapes of his discussions in the White House that ultimately led to his resignation. In 2008, as a judge in the D.C. Circuit, Kavanaugh published another article suggesting policies to improve the functioning of the federal government, which reiterated his support for a law to defer all civil and criminal cases against the president while the president holds office. To be clear, lawyers and legal academics have debated these issues of presidential power and accountability from the founding of the republic. This debate is particularly relevant in light of how easily a governing majority of the president's party can crush congressional efforts to investigate wrongdoing by the president and his administration. Judge Kavanaugh has every right to publish his thoughts for legal academia, but he cannot have it both ways. He cannot spend 20 years arguing that the Constitution forecloses criminal investigations of a sitting president and claim now that he approaches the issue with an open mind. We may soon need clear answers from the court about whether a president can pardon himself and whether he can be subpoenaed, indicted, or otherwise held to account for wrongdoing. If such a case would arise to the Supreme Court, it would be gravely damaging to the court as an institution if the American people were to believe that the president had already secured the votes he needed to win because of his judicial appointments. It's also clear that Judge Kavanaugh comes to this nomination with his mind made up to deliver other important victories to the president and powerful corporate interests at the expense of federal agency autonomy and independence. 2 years ago, Judge Kavanaugh spoke on a panel before a conservative special interest group where he was asked if he could think of a case that deserves to be overturned. After some hesitation, he answered that he would put the final nail in the coffin of Morrison v. Olson, which upheld the constitutionality of an independent counsel who could only be fired for cause by the president. This deserves consideration. When given the chance to name any case he would overturn, Judge Kavanaugh did not think to name any of the most egregious cases from our early history as a nation, such as the now overturned Korematsu decision, which upheld Japanese internment, or Buck v. Bell, which upheld compulsory sterilization of the intellectually disabled. Instead, Justice Kavanaugh made it clear that he would strip Congress of its constitutional authority to protect apolitical public officials like Special Counsel Mueller from arbitrary interference and firing by the president. Just this year, Judge Kavanaugh showed that he was serious. In PHH Corporation versus Consumer Financial Protection Bureau, the full D.C. Circuit upheld the constitutionality of the statute creating the CFPB and providing that its independent director could only be removed by the president for cause. In his scathing dissent, Judge Kavanaugh quoted at length from Justice Scalia's dissent in Morrison v. Olson and made it clear that he would have placed the CFPB director under the thumb of the president. I believe it is safe to assume he would have gone even further in undermining the consumer agency's independence if he had the power to overturn Morrison altogether. This is not the only area where Judge Kavanaugh would deliver long sought-after victories for conservative operatives and special interests. He has also made it clear that he would undercut or even overturn the law of Chevron deference. As this body discussed at length in debate over Justice Gorsuch's nomination, the Chevron case stands for the proposition that when someone sues a federal agency, and a reasonable person could read the statute at issue in more than one way, the court should defer to the agency's reasonable interpretation of the law that the agency is charged with enforcing. Put simply, Chevron prevents big businesses that are trying to escape regulation from pouring millions into lawsuits to second-guess and slow down every piece of a rulemaking process that they don't like. Even Justice Scalia defended Chevron as a reasonable check on judicial activism. But like Judge Gorsuch, Judge Kavanaugh has made it clear in his academic writing that he would overturn Chevron as we know it and systematically tip the scales in favor of well-funded challenges of regulation. In my view, such a major change in the law will put our nation on a path back to the bad old days when companies could pollute the environment, scam their customers, and discriminate against their employees as long as they could pay enough lawyers and get the right judge when a federal agency sues. This would bring us one step closer to the deconstruction of the administrative state that the Trump administration envisions and could severely obstruct future administrations in their efforts to protect consumers, the environment, and those who need a helping hand against the very powerful. We'd like to take a minute to return back to the concept of judicial discretion. As I discussed, I've evaluated every nominee for the Supreme Court during my time in this body based on whether I believe the nominee would have an open mind to be able to use his or her discretion to promote equal justice under the law and to safeguard the powerless against the powerful. Upon review of Justice Kavanaugh's opinions, I do not believe that he would. He has routinely sided with employers and big business against workers, consumers, and those seeking to hold powerful interests to account. Two of his notable opinions illustrate the contrast between his treatment of interests he favors and those he does not. In the case of SeaWorld of Florida versus Perez, it concerned a tragic incident at the theme park in which a killer whale grabbed its trainer and pulled her into the water, killing her. This was not the first trainer whom this whale had killed this way. The Department of Labor sanctioned SeaWorld upon concluding that the company knew about the danger this whale posed to trainers and failed to take reasonable steps to lessen the risk. A federal district court affirmed this conclusion, as well as the District of Columbia Circuit Court. Judge Kavanaugh dissented. He argued that it was inappropriately paternalistic for the federal government to regulate matters of workplace safety for entertaining displays, such as killer whale exhibitions. To him, the free market, rather than potentially life-saving workplace safety standards, should decide how dangerous is too dangerous for workers. Compare this narrow view of a worker's right to a safe workplace with Judge Kavanaugh's broad view of an employer's religious right to opt out of regulations. The case of Priests for Life versus HHS concerned an attempt to broaden the Supreme Court's holding in the Hobby Lobby case. In Hobby Lobby, a 5-4 majority of the Supreme Court held that a closely held for-profit corporation could refuse to comply with the Affordable Care Act's mandate that employers provide health coverage, including contraceptives, on grounds that doing so would conflict with the corporation's purported religious rights under the Religious Freedom Restoration Act, or RFRA. In Priests for Life, a religious nonprofit corporation similarly objected to providing contraceptives to employees on religious grounds, but also objected to an accommodation provided under the Affordable Care Act regulations specifically for religious nonprofits. Under the accommodation, the organization could file a form that lodged a faith-based objection to contraceptive coverage, thereby permitting its employees to access coverage through alternative means, not through the company directly. Priests for Life sued to invalidate even this alternative, claiming that filing the faith-based objection was a religious burden because it caused its employees to receive contraceptive coverage. The D.C. Circuit decided against the organization because the organization was wrong, strictly as a matter of law, that the filing of a form caused a change in employees' access to coverage. Judge Kavanaugh dissented, arguing that it should not matter whether a nonprofit's religious objections were strictly correct as a matter of law in order for the objection to excuse it from complying with the law. If the Supreme Court were to adopt this view, it would open the door to dangerous possibilities. In addition to nonprofits, for-profit corporations like Hobby Lobby and others could use religious objections to excuse themselves from an untold number of federal laws, ignoring in the process the religious and practical needs of the employees, the men and women of conscience who work for them, and the consumers who would suffer the consequences. Contrasting these two cases, one showing Kavanaugh's narrow view of an employee's right to a safe workplace, and the other demonstrating his troublingly broad view of an employer's right to opt out of following the law, it becomes clear to me that Judge Kavanaugh would use his discretion as Supreme Court justice to expand the rights of the powerful at the expense of everyone else. Madam President, Supreme Court justices hold extraordinary positions of authority in our constitutional system because they are the only ones with the power to decide that the governing majority, as well as prior justices on the court, got it wrong. The Constitution guarantees every American certain rights that are beyond the reach of the President or a simple majority of Congress to change because the popular majority cannot always be trusted to protect the interests of the minority, particularly when that minority includes the most powerless, alienated, and derided among us. The Supreme Court's work is not automatic. It is not an assembly line. The men and women who sit on the court must use their values and experience in order to reach the conclusions that determine how the Constitution applies to our daily lives. I read Judge Kavanaugh's legal record to show that he would advance a dangerous partisan agenda from the bench. Some may disagree with that conclusion, but the fact of the matter is that the majority is advancing Judge Kavanaugh's nomination in the absence of critical facts that go directly to his character and value. A full and fair investigation, one without predetermined limits, could clear Justice Kavanaugh's name or it could cause him further trouble. But if the majority proceeds now, and he is confirmed, the shadow of doubt will always linger over his position, over the court, and over the United States Senate. Americans will wonder why this nomination was rushed, and the obvious conclusion will be that it served the interest of partisan politics. Rightly or wrongly, that impression will further harden the cynicism and tribalism of those who are inclined to believe that the system is rigged. That doubt in the fundamental fairness and integrity of our government is contagious, and our whole nation suffers as it spreads. Madam President, I believe that we should stop this and show the American people that facts matter and that character matters. And before I yield the floor, I'd like to say one more thing to my colleague. This process of the majority's elimination of the 60-vote threshold for the Supreme Court to confirm Justice Gorsuch last year is now the precedent for future Supreme Court nominations. Democratic members should expect nothing more from a Republican majority. Every senator should think long and hard about whether they are prepared for what could come next as a result of this dissolution of the Senate rules that historically preserved the institution of the Senate as well as the court. The supermajority requirement for confirmation of Supreme Court justice was a vital backstop against the kind of display we have witnessed here in the past few weeks. That's why Democrats kept the 60-vote requirement in place when they were forced by a Republican blockade of lower court judges to fill a host of judicial vacancies with nominees who had cleared committees for district and circuit courts. Now, with a simple majority threshold, any party in power can pack the Supreme Court on party-aligned votes with nominees like Judge Kavanaugh, who otherwise could never rise to the highest court of the land. I would also note there is no longer any obligation for a nominee to disclose all of his or her records of prior service.
where she is not attacked, where someone like Judge Kavanaugh doesn't get rushed onto the highest court in the land. And I really hope everyone who stood up and spoke out, who was motivated by Dr. Ford and so many others, I hope you are all with me today, tomorrow, and for the fight ahead. So, Madam President, I urge my colleagues to stand with us, to vote no today, and to keep working with us tomorrow. Thank you, Madam President, and I yield the floor.
Madam President.
Senator from Michigan.
Madam President, our nation has seen some deeply concerning trends in recent decades. Increased polarization, flat wages for workers, and a growing tribal mindset that makes it increasingly difficult for people to trust each other and our public institutions. We are also seeing a partisan divide that is growing stronger and wider by the day. For example, 60 years ago, about 4% of Americans said that they would be seriously disappointed if their son or daughter married someone from the opposite political party. Today, it is almost half. We are also seeing a growing economic divide. 50 years ago, 9 out of 10 30-year-olds in America were better off than their parents at the same age. In 2010, only half were. It feels like the bonds that make us a cohesive society are fraying, and that life in the United States is growing more unfair for so many Americans. Bringing our country back together and strengthening our bonds with each other will not be an easy task. But without question, the Supreme Court has an unparalleled ability to either move our society forward or to pull us further apart. Unanimous opinions by the Supreme Court to strike down segregation in public schools, affirm the right of criminal defendants to an attorney, and to rein in the use of executive privilege by President Nixon show the ability of ideologically diverse judges to agree on what is fair and what is right. But the Supreme Court as an institution is far, far from infallible. The same institution that just 3 years ago made marriage equality the law of the land also upheld internment of American citizens of Japanese descent while our parents fought to liberate prisoners held in German concentration camps across the Atlantic Ocean. The same institution that gave American women the right to make decisions about their own reproductive health in Roe versus Wade denied citizenship to African American slaves in the shameful Dred Scott decision. Some of my colleagues have said they have confidence that Judge Kavanaugh believes in Roe versus Wade and that it is the settled law. I hope they're right, but I seriously doubt it. I think that if confirmed, Judge Kavanaugh will spearhead the continued erosion of rights for American women, and if given the chance, will vote to overturn this settled precedent. Lots of talk in Washington about the Supreme Court centers on precedent or power or procedure. But, Madam President, I would argue voting for a Supreme Court nominee is fundamentally about people. In making a decision on how I will vote on a Supreme Court nominee, I ask two questions. First, how will the nominee serve the people of Michigan? And second, how will the nominee serve the nation as a whole? And now more than ever, I think we need our Supreme Court not to be just fair. We also need Americans to truly believe that the justices that make up the Supreme Court are fair, of dispassionate deliberation. No human being, of course, can be entirely impartial or without bias, but we need Supreme Court justices who are able to understand their biases and set them aside for the good of the country. What we need is fairness. What we need is trust. Our fraying social fabric can only be rebuilt by trust. Trust in our institutions, trust in each other, and trust that our courts will give every American a fair chance in an era where corporate profits are ballooning to record levels. But 40% of Americans don't have the savings to cover a $400 emergency expense. A breakdown of trust undermines our democracy. The farther and faster we retreat to our partisan tribal corners, the harder it'll be to ever meet again in the middle. While Americans expect partisanship from their elected officials, they expect better from our judges. Our founders created a co-equal branch of government dedicated to fairness, and that was the Supreme Court. But unfortunately, when I examine the record of Judge Kavanaugh, I do not see an open mind. I do not see fairness. I see a partisan ideologue who will do judicial backflips to rule in favor of large corporations, the powerful, and the elite. When the Supreme Court conducts its duty to advise and consent on Supreme Court nominees, we often talk about methods of constitutional interpretation. Some judges are textualist, some are originalist, some are pragmatist. I believe Judge Kavanaugh is a corporatist, pure and simple. He starts with the outcome that corporate executives would want, and then he works backwards. I believe this is the unifying theme of his rulings over the past decade. Let's take a moment to review his record. Judge Kavanaugh sided with big polluters when he wrote that the Environmental Protection Agency could not enforce their good neighbor rule. This common sense rule simply states whose states with air pollution that blow across their state lines to bear some of the responsibility for those downwind emissions. The good neighbor rule is one of the best ways to crack down on sulfur dioxide, a noxious pollutant that has created a public health crisis in Detroit, with childhood asthma rates almost 40% above the national average. More sulfur dioxide in the air means more children in hospitals and fewer children in the classroom. Judge Kavanaugh substituted his own values and judgment for the decisions of Congress and the EPA, but fortunately, even conservative justices on the Supreme Court voted to overrule him and allow the good neighbor rule to stay in place. Judge Kavanaugh apparently does not believe in good neighbors, and he also does not believe in good bosses. He has consistently ruled against workers and their interest every chance that he gets. He wrote a dissent saying that companies can simply walk away from collective bargaining agreements made with their workers by just creating a spin-off, a non-union company. He ruled that companies can call the police to prevent workers from exercising their right to peacefully picket. For Judge Kavanaugh, the First Amendment right to speech and assembly comes second to a corporation's bottom line. This is the judicial philosophy that the Republican majority is just hours away from elevating to the highest court in the land. Based on a review of Judge Kavanaugh's rulings, it will be clear that if something is good for consumers, he will find a way to oppose it. For example, Judge Kavanaugh sided with large telecom corporations over Michigan families, startups, and small businesses when he wrote a dissent to gut net neutrality protections. Judge Kavanaugh sided with payday lenders, financial fraudsters, and global megabanks when he ruled that the Consumer Financial Protection Bureau was unconstitutional. Not only does Judge Kavanaugh always rule directly in favor of the largest corporations and powerful special interests, his rulings show that he wants to further tilt our campaign finance system in their favor. He has spoken out and ruled in favor of unlimited political spending in federal elections. And in 2011, Judge Kavanaugh authored an opinion that would allow foreign nationals, not Americans, foreign nationals to spend unlimited, yes, unlimited money on issue ads in American elections. Madam President, if you like dark money undermining our free and fair elections, well, Judge Kavanaugh is definitely your guy. I think that Judge Kavanaugh genuinely believes that money is speech and that corporations are people. To him, Americans are only an afterthought. Madam President, I know many Americans are wondering whether Judge Kavanaugh will look out for their best interest if confirmed to the Supreme Court. I hear it all the time as I travel across Michigan. To my fellow Americans, I would say this: if you enjoy breathing clean air, if you have a boss, if you care about not being defrauded by financial bad actors, or if you care about a woman's right to choose, Judge Kavanaugh will not be providing the fairness that you seek. Like many Americans, I followed closely the testimonies of Dr. Ford and Judge Kavanaugh before the Senate Judiciary Committee. And as I watched Dr. Ford, I didn't see a partisan ideologue motivated by politics. What I saw was a woman speaking with credibility, with earnestness, and incredible bravery. As I watched Judge Kavanaugh testify before that same Judiciary Committee, I saw something very different. I didn't see the temperament and humility we expect from a Supreme Court justice. I saw rage and I saw entitlement. I didn't see a thoughtful legal mind bound by precedent or tradition. I saw a partisan political operative cloaked in judicial robes bestowed upon him last decade by a Republican majority flexing their political muscle. I didn't see an umpire who wants to call balls and strikes. I saw a man who believes that he is the league's commissioner, a man who thinks he should have the power to rewrite the rules of the game to help his powerful friends. I didn't see a man committed to fairness and building trust. I saw a man committed to consolidating power and scoring political points. And I saw a man whose fluid relationship with the truth is beneath the United States Senate and beneath the United States Supreme Court. Today, more than ever, Americans need trust, and we need fairness. Judge Kavanaugh's confirmation will provide only more division in our country and cast a cloud over the decisions of the court for years to come. Madam President, I urge my colleagues to oppose Judge Kavanaugh's confirmation and start over with a nominee worthy of our Supreme Court. Madam President, I yield the floor. Suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Madam President.
Senator from Wisconsin.
Madam President, there is one standard that we should apply.
Senate's in a quorum call.
Oh, I ask unanimous consent that the quorum call be dispensed with.
Without objection.
All right.
Senator from Wisconsin.
Thank you. Madam President, there is one standard that we should all apply to any nominee for the United States Supreme Court: honesty. While some have chosen not to apply that standard to Judge Kavanaugh, I must. At the very least, we should expect a nominee for our highest court to be honest. I do not believe Judge Kavanaugh has met this standard. In fact, there is a long record of this nominee not being truthful when he came before the Senate Judiciary Committee. I don't believe that he was truthful in 2006 in his testimony before the Senate, just as I don't believe he was honest in 2018. Last week, I joined millions of Americans in watching Dr. Christine Blasey Ford and her powerful testimony before the Senate Judiciary Committee, in which she credibly presented serious and deeply disturbing allegations of sexual assault. I have deep respect for her strength and the courage she has shown in coming forward and putting her own safety and that of her families on the line to do the right thing. To me, Dr. Blasey Ford was honest, and I believe her. I supported the call for the White House to reopen the FBI background investigation of Judge Kavanaugh. Dr. Blasey Ford did too. However, in his testimony to the Senate Judiciary Committee, Judge Kavanaugh repeatedly refused to support such an investigation by the FBI. It is clear to me that the White House and the Senate Republicans severely limited what could have been a full and independent review by the FBI of the credible allegations against this Supreme Court nominee. The fact is, the White House and Senate Republicans would not allow the FBI to interview Dr. Blasey Ford, Judge Kavanaugh, and a number of witnesses who came forward publicly. That is simply wrong. It is also wrong to be moving forward on a Supreme Court nominee who so clearly lacks the honesty and judicial temperament that we would expect of someone serving on our nation's highest court. Let us not ignore what we all witnessed at last week's Judiciary Committee hearing. We saw a stark contrast between two witnesses. Dr. Ford was honest, credible, respectful, and thoughtful. On the other hand, Judge Kavanaugh was not honest about a number of things he was questioned about, and he did not provide truthful testimony. What he did provide were aggressively angry political attacks that prove that he lacks the judicial temperament to serve on America's highest court. Even before Judge Kavanaugh's recent hearing, I did not believe that he would be an independent judge. Powerful special interests in Washington hand-picked him and have used their massive dark money resources to push his nomination forward. I can only conclude that Judge Kavanaugh would work for them and not the people of Wisconsin or our nation. It is no wonder that Judge Kavanaugh, the choice of these powerful and wealthy corporate special, they want to ensure that they maintain the majority on the Supreme Court that will rule on their issues and in their favor. As my colleague and Judiciary Committee member, Senator Whitehouse, has described in great detail, since 2006, the 5 conservative justices have joined together 73 times as a bare majority in 5-4 rulings in favor of big special interests. These decisions have turned back progress on voting rights, environmental protections, and have allowed corporations to discriminate against workers. Judge Kavanaugh's record shows that he will advance this troubling trend when the people of Wisconsin need a fair, impartial, and independent Supreme Court justice who will stand up for them, not just the big, powerful special interests. At a time when so many in Washington are working to overturn the law of the land that helps provide affordable health care to 133 million Americans with pre-existing conditions, including more than 2 million Wisconsinites, we cannot afford a nominee who would serve as the deciding vote to take us back to the days when powerful insurance companies wrote the rules. The president vowed to appoint judges to the Supreme Court who would overturn the law of the land, Roe versus Wade. And I take him at his word. Judge Kavanaugh is his choice for a lifetime appointment that would turn back the clock on a woman's constitutional right and freedom to make her own health care choices, including access to birth control. I also have serious concerns about Judge Kavanaugh's belief that a president should be protected from investigations and subpoenas and indictments. We have an ongoing national security investigation by the special counsel looking into Russia's attack on our democracy, criminal conspiracy, and potential obstruction of justice. Particularly after his highly partisan testimony before the Judiciary Committee, I do not trust Judge Kavanaugh to provide the independence that we need on our Supreme Court at this time. When Judge Kavanaugh was nominated, I reviewed his record and opposed his nomination because the stakes are too high for the American people. They do not want a Supreme Court to advance a political agenda, to overturn the law of the land on health care for people with pre-existing conditions, women's reproductive health, and the constitutional rights and freedoms of all Americans. I truly wish I had been granted the opportunity to discuss these important issues with Judge Kavanaugh before this vote. But after 7 requests to the White House for a meeting with this nominee, they did not grant me the opportunity to talk to Judge Kavanaugh. The people of Wisconsin need a fair, impartial, and independent Supreme Court justice. Based on everything we know, I do not have the confidence that Judge Kavanaugh would be that justice, and I will vote no on his confirmation to the United States Supreme Court. I would ask for a quorum call.
Clerk will call the roll.
Mr. Alexander.
Senator from Nebraska.
I would ask that the quorum call be vitiated, please.
Without objection.
Madam President, I rise today in support of the nomination of Judge Brett Kavanaugh to be an Associate Justice on the United States Supreme Court. Here in the Senate, the Constitution grants us a solemn responsibility to provide advice and consent to the President's nominees. I was proud to be at the White House as President Trump announced the nomination of this exceptionally qualified judge. After evaluating Judge Kavanaugh's legal record and background, I personally met with him in my office. During our meeting, we covered many topics, including judicial activism. Judge Kavanaugh stated to me that judicial activism is the substitution of policy preferences for stated law. He committed to me that he would never add nor subtract from our country's Constitution, but that he would apply it fairly to all. We had a wide-ranging, hour-long discussion where I shared with him the qualities I want to see in a Supreme Court justice and questioned his record and judicial philosophies. Judges are not legislators or activists. They are interpreters of the law. They must have integrity and understand that all Americans must be treated equally under the law. Judges must uphold high standards with a fair-minded approach, tremendous intellectual capacity, and devotion to the public good. Madam President, I am confident that Judge Kavanaugh possesses all of these qualities. Moreover, I was impressed by his commitment to the rule of law. He understands the proper role of a judge as an interpreter, not the writer of the law. He also understands that unlike members of Congress or the executive branch who are accountable to the people, the judiciary must act independently and follow the law wherever it takes them. This was something we heard repeatedly from him in his lengthy confirmation hearing before the Senate Judiciary Committee. Judge Kavanaugh demonstrated his strong commitment to judicial independence. During the hearing, he repeatedly affirmed that, quote, "What makes a good judge is independence, not being swayed by political or public pressure. That takes some backbone. It takes some judicial fortitude. The great moments in American judicial history, the judges had backbone and independence." He continued, "Judges make decisions based on law, not on policy, not based on political pressure, not based on the identity of the parties. No matter who you are, no matter where you come from, no matter how rich you are, how poor you are, no matter your race, your gender, no matter your station in life, no matter your position in government, it's all equal justice under law," end quote. I believe his words and judicial philosophy are what every member of the Senate, Republican or Democrat, should require from their nominee. I also admired Judge Kavanaugh's appreciation of the Supreme Court's position in setting and interpreting precedent. He's even written a book on it, and I am comfortable with his understanding and appreciation for the role of precedent in the judicial process. For 12 years, Judge Kavanaugh has served on the D.C. Circuit Court of Appeals, our nation's second most influential court. His record is remarkable. With nearly 200 controlling opinions, he has proven to be one of the most thoughtful, preeminent judges in our nation. In 13 cases, the Supreme Court adopted Judge Kavanaugh's reasoning in his decisions. This is a key point. as it was not just 13 decisions in agreement. It was Judge Kavanaugh's actual language and the thought process in his decisions which were used in the opinions of our nation's highest court. The logic behind Judge Kavanaugh's opinions are already woven into Supreme Court precedent. Regarding privacy issues, in United States versus Jones, Judge Kavanaugh dissented when the court denied the government's request for a rehearing. He argued that the case deserved to be heard by the full court and indicated support for the narrow, property-based Fourth Amendment argument made by the plaintiff. When considering whether a warrant was required in order to install a GPS tracker in a suspect's car, he said the suspect's property rights should have been taken into account. In Justice Scalia's majority opinion, he agreed with Kavanaugh's property-based approach. When it comes to administrative law, he is taking a consistent and balanced approach to assess congressional intent and implying exceptions to Chevron deference, ensuring that federal agencies are executing the laws crafted by Congress, not creating their own versions of the law. According to his words, Judge Kavanaugh looks to the settled, bedrock principles of constitutional law. In protecting Congress, he has found that, quote, the president and federal agencies may not ignore statutory mandates or prohibitions merely because of policy disagreement with Congress. Judge Kavanaugh also has a strong comprehension of freedom of speech under the First Amendment. He demonstrated this in his decision in the case of Bordley versus the United States Department of Interior. This particular case dealt with a Christian man, Michael Bordley, who was stopped by the National Park Service from handing out pamphlets on his faith at Mount Rushmore. Judge Kavanaugh joined the majority in ruling against the Park Service and their exceedingly broad regulation of free speech. In authoring hundreds of opinions while joining hundreds of others, Judge Kavanaugh has distinguished himself as a thought leader on the federal bench. Madam President, over the past few weeks, I believe the Senate confirmation process has become a shameful spectacle and a disservice to everyone involved. I appreciate Professor Ford's sincere testimony. I believe she has experienced a traumatic event that no woman should have to endure. There is no evidence, though, that Judge Kavanaugh was the perpetrator. A 7th FBI background investigation of Judge Kavanaugh failed to corroborate Professor Ford's account. Moreover, there are a number of key facts from Professor Ford's story. My job as a senator is to assess the facts and make a judgment. I continue to support Judge Kavanaugh and believe he will serve our nation with integrity and devotion to the rule of law. I am confident that Judge Kavanaugh will be an outstanding Supreme Court justice. I look forward to voting in favor of his confirmation. He will serve the American people with distinction. Thank you, Madam President. I would suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Madam President.
Senator from Massachusetts.
Madam President, I ask for a vitiation of the quorum call.
Without objection.
Thank you, Madam President. Madam President, I ask unanimous consent that 3 letters and a news article related to allegations against Judge Kavanaugh be entered into the record.
Without objection.
Thank you, Madam President. Madam President, I rise to speak in opposition to the nomination of Judge Brett Kavanaugh to serve as an Associate Justice on the United States Supreme Court. The vacancy that Judge Kavanaugh seeks to fill is not an ordinary one. The retirement of Supreme Court Justice Anthony Kennedy created one of the most consequential vacancies on the High Court that this country has ever seen. There is a reason why scholars and pundits refer to the Supreme Court of the last 30 years as the Kennedy Court. His influence on so many important cases cannot be overstated. Throughout his 3 decades on the Supreme Court, Justice Kennedy was often the swing vote in decisions decided 5-4 on a divided bench. After John Roberts became Chief Justice in 2005, Justice Kennedy was the deciding vote in 92% of all cases decided by 1 vote. Let me repeat that. Of the 203 cases decided by a 5-4 court in the John Roberts era, Justice Kennedy was the deciding vote in 186 of them, 92%. The justice who succeeds Anthony Kennedy on the Supreme Court will have the opportunity to leave a deep and lasting mark on issues of the highest magnitude. Any nominee to the Supreme Court carries significance, but a nominee at this moment for this seat will play a defining role in our nation's history. The constitutional obligation conferred on senators to provide their advice and consent on a Supreme Court nomination is a powerful, a serious, and a sacred responsibility. As senators, we are duty-bound to determine whether Brett Kavanaugh is worthy of our trust. Even President Trump nominated Brett Kavanaugh to the Supreme Court, there were serious concerns that he were too extreme, that he lacked the independence we seek in our judges, and that he had a difficult relationship with the truth. During the confirmation process for his current position on the U.S. Court of Appeals for the D.C. Circuit, Brett Kavanaugh made misleading statements under oath to the Senate Judiciary Committee on issues such as the Bush administration's policies on torture, his involvement in the nominations of controversial judges, and his knowledge about the theft of emails from the Democratic staff of the Senate Judiciary Committee. Then, when it came time to fill Justice Kennedy's seat on the Supreme Court, Judge Kavanaugh was handpicked by the Federalist Society, an ultra-conservative group dedicated to installing far-right judges on our bench. The Federalist Society promised Donald Trump that the judges on that list would support his partisan agenda if they were elevated to the Supreme Court. And Donald Trump repeatedly assured his supporters about that agenda, promising them that he would only appoint justices to the Supreme Court who would overturn Roe v. Wade and the Affordable Care Act. Let me restate that. Donald Trump promised that he would only only appoint justices to the Supreme Court who would overturn Roe v. Wade and the Affordable Care Act. As to Brett Kavanaugh, the promises that Donald Trump and the Federalist Society made were backed up by Kavanaugh's judicial record on the D.C. Circuit. As a federal appeals court judge, Brett Kavanaugh wrote a dissenting opinion questioning Congress's authority to an Affordable Care Act and suggesting that the president could choose not to enforce it. Judge Kavanaugh would have blocked a lower court's order allowing an undocumented minor to safely and legally terminate her pregnancy. Judge Kavanaugh supported employers who sought to deny their employees access to contraception. Judge Kavanaugh wrote an opinion that unless guns were regulated either at the time the Constitution was written or traditionally throughout history, they cannot be regulated now. He would have struck down the District of Columbia's assault weapons ban because assault weapons have not historically been banned. And how about 3D downloaded guns? That wasn't in the original Constitution. There was no 3D guns. Are we bound by what the Founding Fathers thought about weapons? Or can we ourselves make a determination here? He says, no, it goes back to the time when the Constitution was drafted or throughout history, but not today. And that's just wrong. Judge Kavanaugh has consistently opposed strong environmental protections and sought to restrict the authority of the Environmental Protection Agency. And he authored a dissenting opinion that argued that net neutrality were unconstitutional. Time and time again, on all these issues, access to health care, gun control, consumer and environmental protections, and a free and open internet, Judge Kavanaugh has been a rubber stamp for a far right-wing agenda. But that's not the only reason President Trump chose Brett Kavanaugh for the Supreme Court. Judge Kavanaugh, who once served as Ken Starr's top deputy in the investigation of President Clinton, has since written that a sitting president should not be investigated for allegations of wrongdoing, should not be indicted or tried while in office, and should not even have to participate in civil legal proceedings until he leaves office. That's a convenient reversal of a pro-investigation, pro-litigation position that Kavanaugh held when a Democrat was in the White House. It's a reversal that synchronizes very well with Donald Trump's interests. When Donald Trump, under criminal investigation, with legal issues arising from that investigation potentially headed to the Supreme Court, and with Brett Kavanaugh having articulated strong views about shielding a sitting president from criminal proceedings, his confirmation is a constitutional crisis in the making. It is no coincidence that a president who fears the long arm of the law would nominate to the Supreme Court a jurist who would keep him from its reach. Brett Kavanaugh has left a lengthy paper trail on all these hot-button issues, and that's why President Trump and his allies closed ranks and fought to keep so much of his public record hidden from the American public. Despite repeated requests from Senate Democrats for documents relating to Brett Kavanaugh's service in the Bush White House, we, the members of the Senate, have only seen 7% of those records that were, in fact, part of Kavanaugh's record inside of the Bush White House. And only about half of that 7% are available to the public. To put it another way, no other senator has seen 93% of all of Brett Kavanaugh's work in the White House. That work includes reflections on his views on the detention of enemy combatants, interrogation techniques, the use of torture, warrantless wiretapping, banning of same-sex marriage. We, here on the Senate floor, as we cast a vote today, we do not have access to any of those documents that he worked on while serving in the Bush White House. How can we give advice before we vote on consent if we can't even gain access to the documents which he himself handled in the Bush White House, which he himself may have commented upon during the time that they were being considered? We have no access to it. 93% of all of the documents are not available to the members of the Senate. And even though there are reams of paper detailing Brett Kavanaugh's involvement on these issues, his record on them remains a blank slate for senators. So, to summarize, even before the events of the last 3 weeks, we know a lot of things about Brett Kavanaugh, and yet, at the same time, we know shockingly little about Brett Kavanaugh. We have someone in his life who has been a blatantly partisan person. But as you're trying to be nominated for the Supreme Court, we, the senators, the American public, they have to know what you think about issues. And that is why every preceding nominee has had to provide all of the documentations, with the notable exception of Brett Kavanaugh, who is denying us 93%. And that is happening with of the Trump White House and the Republican leadership here in the Senate. No member of the Senate, Democrat or Republican, knows what's in those 93% of all the papers. No one knows. It's a deliberate cover-up of all of those documents so that we cannot know, that public cannot know. So we begin with that. 93% of all of his record in the White House is not acceptable, is not accessible to us, even though this nominee is given to us from this White House. So we know a lot, but there's much, much more that we do not know. We knew that we had a Federalist Society-approved nominee who would overturn Roe and the Affordable Care Act. We knew we had a president with a vested interest in finding a future justice who could shield him from legal jeopardy. And we knew that there was much else we didn't know because that 90%, that 93% was being hidden from public scrutiny. All these reasons alone were enough to warrant a no vote on Judge Kavanaugh's lifetime appointment to the Supreme Court. But then we learned of Dr. Christine Blasey Ford. Dr. Blasey Ford bravely came forward to tell us about the Brett Kavanaugh she knew. She came forward to share a deeply personal and traumatic experience of sexual assault. Dr. Blasey Ford did not want to share this painful story with the American public. She did not want to have her life upturned and picked apart. She did not want to subject her family to harassment and death threats. She did not want the President of the United States to shamefully and appallingly mock her at a political rally. But she came forward anyway. She came forward because she believed it was her civic duty to do so. From the beginning, it was clear that her allegations were credible. She had recounted the painful experiences to her husband in couples counseling years before Brett Kavanaugh was ever considered for the Supreme Court, something that her therapist's contemporaneous notes corroborate. 3 days before Brett Kavanaugh was nominated, while her name was publicly in play for the Supreme Court, Dr. Blasey Ford reached out to her Congresswoman in the hope that she could help inform President Trump as he decided on a nominee to fill Justice Kennedy's seat. Dr. Blasey Ford took a polygraph test to prove that she was truthful, and she only shared her story publicly when reporters made it untenable to remain silent. Every detail shows Dr. Blasey Ford to be consistent, honest, and trustworthy. And as hard as it was for her, Dr. Ford did our country an invaluable service by coming forward, testifying before the Senate, and telling the entire country her story. Her testimony was powerful. It was heart-wrenching. When she spoke of her strongest memory of the assault, the laughter of the two boys as Brett Kavanaugh pinned her down, we felt her profound pain. When she spoke of Brett Kavanaugh covering her mouth as she tried to scream, we felt her visceral fear. And for countless women and men across the country whose experiences mirror that of Dr. Blasey Ford, this testimony was their voice. For many of them, Dr. Blasey Ford's bravery gave them the courage to come forward with their own stories of sexual assault. On the day of her testimony, my office received over 100 calls from survivors who courageously shared with my staff the painful details of their own assault. Many of these men and women were telling their stories for the first time. Women have stopped me at the airport on the street to tell me their stories. Dr. Blasey has given them the courage to come forward so that they can share their own experiences. Dr. Ford's courage opened a wellspring of emotion. I applaud her. We owe her a deep debt of gratitude. She was a role model for all of us, for the children of the country, and for future generations. She has given new meaning to what it means to be a good citizen. Dr. Ford was compelling. She was convincing. She was courageous. She had nothing to gain and everything to lose. No reasonable, open-minded person could have listened to Dr. Blasey Ford and concluded anything other than that she is telling the truth about what happened between her and Brett Kavanaugh. But there are two sides to every story. What about the other side of the story? What did Judge Brett Kavanaugh have to say about it after Dr. Ford testified before the Judiciary Committee? It was Judge Kavanaugh's turn. And what did we hear from Judge Kavanaugh? We heard anger. We heard belligerence. We heard evasiveness. We heard disrespect. Judge Kavanaugh's testimony before the Judiciary Committee reinforced the old concerns about his credibility. He gave answers about his behavior in high school, about supposed drinking games, and about his yearbook page that simply defy credulity. Recent reports from those who know him in high school and college contradict his assertions that he was never aggressive or belligerent after drinking, or that used in his yearbook had the meanings he ascribed to them before the Judiciary Committee. In fact, in a letter that Brett Kavanaugh himself wrote in 1983 that surfaced after his testimony, he described himself and his friends as, quote, loud, obnoxious drunks. The point is not that Brett Kavanaugh engaged in questionable behavior in high school. The point is that he was not honest about it with the Judiciary Committee under oath at his confirmation hearing. The point is that he was not credible. The point is that he misled the Judiciary Committee. The point is that if, as my colleagues framed the issue yesterday, we are assessing whether Dr. Ford's allegations satisfy a more likely than standard, they do, and do so easily. That Judge Kavanaugh showed an alarming lack of judicial temperament in addressing those issues. But don't take my word for it. Consider what Judge Brett Kavanaugh has to say. What would Judge Brett Kavanaugh say about Supreme Court nominee Brett Kavanaugh's appearance before the Judiciary Committee? Well, in 2015, Judge Brett Kavanaugh gave a speech at the Catholic University on what makes a good judge. He set forth litmus tests for a good judge, the characteristics and qualities he or she must have. Here's what he said then. Brett Kavanaugh said, a good judge, like a good umpire, cannot act like a partisan. He went on to say that it is very important for a judge, quote, to avoid any semblance of that partisanship, that political background. Yet, in his opening statement to the Judiciary Committee, Judge Kavanaugh launched into a nakedly partisan screed. He blamed Democratic senators for a conspiracy to destroy his nomination. He called the recent allegations against him a part of some revenge of the Clintons. He told the Democratic senators on the dais that what goes around comes around, making an unvarnished political threat in his opening statement to the Judiciary Committee. Judge Kavanaugh failed his own test of partisanship. And next, in his 2015 Catholic University speech, Judge Kavanaugh said that, quote, it is critical to have the proper demeanor. Judge Kavanaugh added that it is important for judges, quote, to keep our emotions in check and become against the storm. Anyone watching Judge Kavanaugh's testimony before the Judiciary Committee saw just the opposite. Judge Kavanaugh was angry, emotional, and belligerent. What we saw was a performance we'd expect from a judge on the People's Court, not on the Supreme Court of the United States. Judge Kavanaugh failed his own test for judicial temperament. And finally, in his 2015 Catholic University speech, Judge Kavanaugh counseled that a good judge, quote, must demonstrate civility. Yet in his appearance before the Judiciary Committee, Judge Kavanaugh impugned the motives of Democratic senators. He was rude. He interrupted questions. He went so far as to ask my colleague, Senator Klobuchar, whether she ever blacked out from drinking, an affront by a nominee who was there to provide answers, not to ask questions. Brett Kavanaugh failed the test of civility. And that is why more than 2,400 law professors have written to the Senate and told us, quote, Judge Brett Kavanaugh displayed a lack of judicial temperament that would be disqualifying for any court, and certainly for elevation to the highest court of this land. And that is why former Supreme Court Justice John Paul Stevens took the extraordinary step of stating publicly that Judge Kavanaugh's performance at his confirmation hearing disqualified him from serving on the Supreme Court. Let us remember this. Brett Kavanaugh is not entitled to a job on the Supreme Court. No one is. But the American people are entitled to the truth. And President Trump and the Senate Republicans have kept it from them. The FBI background investigation that was reopened after Dr. Blasey Ford's testimony was not a real investigation. It was a fig leaf to cover for Republicans with concerns about Judge Kavanaugh. The FBI interviewed only 9 witnesses. Unbelievably, Dr. Blasey Ford and Brett Kavanaugh were not amongst the people interviewed to review the results of the so-called investigation. I was locked in a secure room with 17 senators and 1 copy of the FBI report for all of us. It was like a bad game show where senators competed with each other to get pages of the report from the hands of their colleagues, read them and digest them before the clock ran out on the 1 hour we were given to read those reports. It was the single most absurd thing I have experienced in my time in Congress. And sadly, it was entirely consistent with the manner in which the Senate Republicans have handled this nomination throughout the confirmation process. And that's why, because the White House weren't interested in getting to the truth. They were interested in covering it up and ramming through Judge Kavanaugh's. They have gone so far as to stoke claims that Dr. Ford's supporters have an ulterior motive, that Dr. Ford is being used for political reasons. It seems that many of my Republican colleagues just cannot bring themselves to believe that a woman's account of a sexual assault and that other women and men have also experienced would rise up in support of her. That is shameful that people think that that is what has occurred. Just shameful. Article 3 of the Constitution says that a Supreme Court justice shall hold office during good behavior. That's the standard after someone serves on the Supreme Court. What this body has been unwilling to do is to actually determine whether or not Judge Kavanaugh has engaged in good behavior before he is put on the court. They have truncated that process. They have made it impossible for us to get to the bottom of that truth. The Republicans control this chamber. They control the schedule. They have rushed to judgment on Brett Kavanaugh in order to confirm him before the midterm elections. They have 51 votes to confirm anyone they want. The Democrats do not control this chamber. They have the 51 votes. If they wanted to bring in someone else that did not have these problems, they could have done it at any time. They could do it today. We have no power to stop the Republicans from confirming a justice this year. No power. That is absolutely untrue. What the Republicans had in their power, however, is to nominate someone, even today, who is worthy of serving on the Supreme Court. We know they want a Supreme Court justice who will overturn Roe v. Wade. We know they want a Supreme Court justice who will take away health insurance coverage for pre-existing conditions. We know they want a justice who will oppose any gun control. And we know they want a Supreme Court justice who won't question Donald Trump or let him be investigated. If Brett Kavanaugh is confirmed, it will further harm a Supreme Court that has never fully recovered from Bush versus Gore, the partisan decision that threw the 2000 presidential election to George W. Bush. It will further harm a Supreme Court that has not recovered from Judge Neil Gorsuch's joining the court after Senate Republicans stole that seat from Judge Merrick Garland. Confirming Brett Kavanaugh to the Supreme Court will further erode and undermine the court's legitimacy and continue to diminish the American people's trust in it. The Supreme Court of the United States deserves better than Brett Kavanaugh. The American people deserve better of the United States, and I urge my colleagues to vote no as well. Thank you, Madam President. Isn't so quorum.
Clerk will call the roll.
Mr. Alexander.
Madam President,
Senator.
Abstract legal principles that are reserved for a few. Its decisions affect the rights of all of us. They touch on issues that affect all of our daily lives, from the health care we receive, to the person we marry, to the air that we breathe. I announced my opposition to Judge Kavanaugh's nomination based on concerns that I had with his record. And even though, as Senator Markey pointed out so eloquently, We haven't gotten to see a lot of that record. We have enough to know very serious concerns about Judge Kavanaugh. I want to talk about a couple of those. Highlight three, actually, concerns. First is his opposition to the Affordable Care Act. No, I believe all Americans in this country, everyone in this country, should have access to health care that they can afford so they don't have to worry when they need to take their kids to the doctor, so that they don't have to worry about being bankrupt because they can't afford the costs, about having to worry if they get a serious illness. And yet, Judge Kavanaugh dissented in a decision to uphold the Affordable Care Act. And as the result of that decision, he puts critical protections for millions of Americans with pre-existing conditions at risk. And it's particularly concerning now when we know there is a court case in Texas that the government of the United States has declined to continue to defend, that puts at risk the requirement that insurance companies cover those with pre-existing conditions. And, you know, you can talk about trying to Band-Aid over that every way you want. The fact is, unless we have a real health care program as we have under the Affordable Care Act, insurance companies are not going to cover people with pre-existing conditions, and they're going to charge you more if they do cover you. Second, I'm very concerned about his opposition to women's reproductive rights. Judge Kavanaugh has praised Justice Rehnquist's dissent in the landmark Roe v. Wade decision that guarantees women the right to make their own reproductive health decisions. I believe that's one of the most basic and fundamental rights that we have, not just as women, but that families have. You know, women should be able to make that decision in consultation with their families, with their physicians, with their religious beliefs, and this should not be something that the government dictates. Now, finally, I have a serious concern about Judge Kavanaugh's view of executive branch power that could place the president above the law. Judge Kavanaugh has said that sitting presidents can't be indicted, can't be prosecuted, and should have the authority to fire a special counsel at will. Well, with the Mueller investigation, with so many concerns that have been raised about this president's manipulation of laws that have allowed him to enrich himself and his company, that suggests that where he has been suggesting that he may fire the Attorney General because he's not willing to do his bidding at the Justice Department. I just don't see how we can put somebody on the Supreme Court who thinks that the president is above the law. You know, as I learned American history and our Constitution and our values and principles, I believe that nobody is above the law in our democracy, including the President of the United States. And I think we need a Supreme Court justice who believes the same thing. And yet what we've heard from Judge Kavanaugh suggests that he thinks the president is above the law. Now, at the time I announced my opposition to the nominee, we had not heard the allegations of sexual assault against Judge Kavanaugh. In the weeks since those have come out, this Senate, this country, have been rocked by those allegations. I was one of the many millions of Americans throughout the country who tuned in to closely watch that hearing when Christine Blasey Ford shared her story. Her testimony in front of the Judiciary Committee was sincere and credible, and I believe her. The impact of Dr. Ford's testimony is very telling about the pervasiveness of sexual violence in our culture. The allegations made by Christine Ford and others were serious and trustworthy, and I believe they should have been thoroughly and impartially investigated, and they were not. But on the positive side, Dr. Ford's bravery has given so many women in this country the courage to tell their stories. She gave others courage, and we have seen an outpouring from survivors who now feel like they too can come forward. Senator Markey talked about the number of people that he's heard from in his office, and I've heard that same story time and again from so many of my colleagues. We're certainly seeing this in New Hampshire. The Sexual Harassment and Rape Prevention Program, which is also called SHARP, a program at the University of New Hampshire that provides services and support to sexual assault survivors. They've reported an increase in people for help. And I've heard that from crisis centers across the Granite State, who fielded an influx of calls from survivors who can relate to Dr. Ford's testimony and who feel compelled to speak out. On Tuesday, I spoke with the New Hampshire Coalition Against Domestic and Sexual Violence, which told me they've seen similar interactions with survivors who are now stepping forward, women and men whose trauma of past sexual assaults has been revived by Christine Ford's testimony. Like my colleagues, I've received letters from sexual assault survivors who've been deeply affected by Dr. Ford's testimony and whose courage has given them the strength to share their own stories. What's been amazing to me as I read them, what I've heard from people who have contacted our office, is that some of them are in their 70s and 80s, and they reveal decades-old sexual assaults for the very first time. These wounds are real. The wounds are raw, and it is incumbent on all of us in this body, regardless of where you stand on Brett Kavanaugh. It's incumbent on all of us to not deepen those scars by diminishing the pain of these women as political theater. This is not political theater, and it should not be viewed through a partisan lens. In those emotional emails and calls and letters from dozens of women and a few men, I think sometimes we forget that sexual assault doesn't just happen to women, it happens to men. They have described their sexual assaults and how they have been affected by the events of Christine Ford's testimony and the hearing with Judge Kavanaugh. And so many of those letters and emails, they talk about the details of what they experienced in those sexual assaults, how it affected them, how it's affected their lives. The fact that in most cases, they didn't tell anybody because they didn't feel like they would be believed, or they thought they would be demeaned, or they thought it was their fault. But what's been interesting to me as part of those letters and emails has been that so many of the people we've heard from have not just told their personal stories, but they have expressed their concerns about the country as part of writing in. Concerns that we're so divided, that we're so angry, that we're so uncivil to one another. And sadly, they're right. based on what they've seen over the last couple of weeks. We've seen that at political rallies over the past few years, and we've seen it in this building. And we must do better. The disunity that we model here is hurting the country. The scorched earth politics that have been practiced here are deepening our divides. Now, I will oppose Judge Kavanaugh's nomination, and I continue to hope that something may happen at the 11th hour. I know that's not likely. But I also will encourage my colleagues on both sides of the aisle to think about this moment, to reflect on our obligations to the American people, to the United States Senate, and to considering future Supreme Court nominees. As so many people have said, this process has undermined the faith of the American people in the ability of the Supreme Court to be an objective arbiter of cases that come before them. This process has inflamed existing divides within our country and within Congress, and we can't let this become the status quo. As an institution, as a legislative body, we must. Now, I've always been told that when we're standing at the edge of an abyss, the best step is always backwards. So I hope all of us can take a step back. I hope we can take a step back when we're past this nomination, that we can return to more civil discourse. I hope that we can better try to understand each other's point of view and that we can see each other's humanity. And I hope we can be better stewards of our democracy because this country demands it. Thank you, Madam President. Absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Madam President.
Senator from Ohio.
Thank you, Madam President. I ask unanimous consent to dispense with the quorum.
Without objection.
Madam President, I announce my decision to vote against Gill in support of corporate interest. He has consistently sided with corporate special interest, large corporations which outsource jobs over workers, and has sided with Wall Street over consumers. I made that decision before Dr. Ford came forward. But I'm grateful for her. I'm grateful she did, even at great personal cost and personal risk. I believe Dr. Ford. Why in the world would someone do what she did, again, at great personal cost and great personal risk, if she weren't telling the truth precisely? I'm grateful to her. I'm grateful for all the brave women inspired by her to speak out and share their own stories. Many of them have written to my office. A number of them I've spoken to on the phone. Some of them told us for the first time in their lives after one woman was in her 70s, and it was the first time she had spoken of her sexual assault. Please understand, to all the people, all the women and men, and I've gotten letters from men too, but mostly women, understand, to all of you and all over the country, we see you, we hear you, your story matters, and you make a difference. It's wrong that political influence and artificial deadlines put on them, these deadlines imposed by the majority leader down the hall and the President of the United States, artificial deadlines and political influence prevented the FBI from performing the complete and thorough investigation the American people deserve. Instead, Senate leaders in the White House straitjacketed the FBI. I don't blame the FBI. They only did what Senate leaders, what Republican leaders who wanted to ram this nomination through as quickly as possible, and the White House, who would never want to compromise on anything like this. They straitjacketed the FBI. They kept our law enforcement professionals from doing their job. According to Dr. Ford's lawyer, the FBI didn't even speak to more than a dozen witnesses that Dr. Ford asked them to interview. So they are trying to corroborate whether her story was true, but then the FBI then didn't interview Dr. Ford or Judge Kavanaugh, nor did they interview the people that Dr. Ford suggested them to, the names that Dr. Ford gave them, people who could corroborate what happened. So the FBI did not interview any of the people that Dr.